bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Wade Wilson. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen. Okay, you guys, in the last video where we discussed Wade Wilson, we discussed the appeal brief that he filed in his case. Specifically, he was talking about the fact that he feels like his sentences to death should be reversed, right? Since then, or after that, the state of Florida, so the prosecutors for the state of Florida, filed their response. And that's going to be the subject of this video. So let's go ahead and get started. Before we get started, okay, I'm gonna tell you this. A lot of these briefs are over 100 pages. A lot of them are over 100 pages. And I think I've promised to you guys in a lot of my videos that if you guys want, I can link it down below because I'm not gonna read everything word for word. I trust you guys and I know you guys know how to read, period. Okay. I just do this because I want to interpret some of these things for you and also to provide you my opinions and provide some legal analysis as to, right? All that to say, I'm not reading all 127 pages of this brief. We're going to summarize the argument, give you my thoughts and opinions on it. I can link it down below if you guys want me to link it down below. And that's just going to be that. Let's carry on. Summary of the argument. Appellant failed to properly preserve this issue. In any event, there is no ex post facto violation because the amended sentencing statute is purely procedural and does not change the substantive law. Also, the amended statute was not applied retroactively, but prospectively under Florida law because the sentencing hearing occurred after the legislator's effective date. However, appellant waived the argument that its application violated the statute because he failed to raise it in the trial court. 2. There is no violation of Ramos v. Louisiana because the case only requires unanimous verdicts to convict a defendant that does not apply to sentencing at all, let alone require a unanimous jury to recommend a death sentence. 3. Aggravators and jury instructions provide sufficient guidance to avoid arbitrary and capricious sentencing. 4. This argument is waived because it is not properly briefed. Regardless, the hack, aggravator, and instructions are not unconstitutional either on their face or as applied to appellant. The jury instructions provided sufficient guidance to the sentencing jury to avoid applying the hack aggravator in an arbitrary, capricious, and inconsistent manner. 5. This argument is waived because it is not properly briefed. Regardless, the CCP aggravator and instructions are neither unconstitutional in their face or as applied to appellant because the jury instructions provided sufficient guidance to the sentencing jury to avoid applying the CCP aggravator in an arbitrary, capricious, and inconsistent manner. 6. This argument is waived because it's not properly briefed. Regardless, the victim impact evidence did not render the sentence unconstitutional because Florida's statute only permits the type of testimony that the United States Supreme Court previously approved. In addition, because there was no contemporaneous objection to any of the testimony, appellant cannot complain that any particular testimony failed to comply with Florida's statute. Woo! That was a whole lot, you guys, but let me go ahead and try to explain some of that to you. A lot of times when attorneys are making arguments, we do things that I like to call yes, but. Let me try to see, as I explain this to you guys, let me see if I find a better way to explain it. But basically what we say is this: Judge, I don't agree with the argument that is made. Okay, here's my basic narrow explanation of why I don't agree. So like, for example, here they're saying it wasn't properly briefed, right? But you don't leave it just there. Then you say, however, should the court disagree with the argument that I just made that it's not properly briefed and even consider this argument, here is why it also fails, right? And we do that a lot. I do it in pretty much everything, every motion I write, honestly, because I'm like, you know, this should be dismissed because X, Y, Z. But Judge, if you're not buying that today, let me lay out some more framework for you, basically, is what we do all the time. I think that it's smart of the state prosecutors to frame it this way. I think a lot of us do it this way, and I like the way they worded it. Another thing that the prosecution did really nicely here was that it mentioned the fact that the defense attorneys didn't contemporaneously object to something, so they have thereby waived the objection. In a lot of different criminal cases or criminal trials that you guys have seen, defense attorneys will object to something, you know, probably expecting the objection to be overruled, but they'll object to it nonetheless just to preserve the record for appeal, right? I think there's even cases that we've probably discussed on this channel or trials that we've watched together where the defense attorney will just say that, Your Honor, I'm just raising the objection for appeal or to preserve the record or to, they'll just say stuff like that. And I think that's a valid way to say it. So even if a defense attorney feels like the objection is going to be overruled, you just make it anyway. Don't make a stink about it, but just like, hey, judge, it's me protecting my client, blah, blah, blah. Like just say it, just say it. And I think that's what they're mentioning here. But let's go ahead and carry on. The trial court's ruling correctly determined that applying the amended 921.141 did not violate ex post facto principles. Article 1 of the United States Constitution prevents both Congress and any state from passing any ex post facto law. On January 11th, 2024, appellant filed a motion seeking that the trial court apply in his case the version of Florida Statute 921.141 in effect prior to its April 23rd, 2023 amendment. In the motion, he argued that the proper law to apply was the law in effect at the time the crime was committed and that applying the amended version of the statute violated the ex post facto provisions of both the United States and Florida constitutions. The trial court denied the motion on March 14th, 2014. The court, in its decision, relied on Daubert v. Florida and Victorino v. State. The court concluded that because the amendment to Florida Statute 921.141 does not criminalize an act that was previously innocent, does not increase the potential sentence of an existing crime, and does not alter the proof necessary to impose the death penalty, the recent change is not ex post facto. Although appellant contends that the trial court's use of the newly amended statute rather than the version that was in effect when he murdered Christine Melton and Diane Ruiz in 2019 violates the ex post facto clauses of both the United States Constitution and the Florida Constitution, the trial court properly relied upon Daubert, in which the United States Supreme Court previously rejected a similar claim. In Daubert, the defendant murdered his young daughter in December of 1971 and then his young son sometime in early 1972. At the time of the 1971 murder, Florida's death penalty statute provided that a person convicted of a capital felony was to be punished by death unless the verdict included a recommendation of mercy by a majority of the jury. After the murder, the United States Supreme Court in Furman v. Georgia struck down capital punishment as violating the Eighth Amendment. In response to Furman, many states, including Florida, enacted new death penalty statutes. Daubert was convicted of the first-degree murder of his daughter and sentenced to death using the post-Furman amended death penalty statute enacted after he committed his crime. Among Daubert's claims raised were ex post facto challenges to Florida's amended death penalty statute. His ex post facto challenge relevant to the court's consideration of this case, modifications made to the function of judge and jury in imposing death sentences was a similar challenge to the one appellant poses here. It addressed the constitutionality of applying the change made between the time he committed the crimes and the time he was sentenced for them. The Supreme Court noted that even though a procedural change may work to the disadvantage of a defendant, a procedural change does not create ex post facto concerns. The court concluded that there were no ex post facto violations because the changes in law were procedural and ameliorative. The court found the amendments to Florida's death penalty statute were procedural because they merely altered the methods employed in determining whether the death penalty was to be imposed. There was no change in the quantum punishment attached to the crime. As the court noted, the crime, the punishment, and the quantity of the degree of proof necessary to establish his guilt all remained unaffected by the amendments. Let's just stop right here and I'm going to explain that to you guys. Do you guys remember in my last Wade Wilson video when I was saying or explaining exactly what ex post facto was? And I was telling you guys that what Wade, or by virtue of his attorneys, what Wade is arguing is that they should have used a different law that was enacted in 2019 when the crimes were committed and not the 2023 law that was used here, right? Basically is what they're saying. So here the prosecution is saying, no, 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 no. Here's all this case law that says when he's sentenced is what matters, not when the crime is committed, right? And I tend to agree with the prosecution here. I think that the argument that defense is making is clever, but in my opinion, it doesn't hold much weight. Yeah, I'm just persuaded. I'm persuaded by the prosecution's argument on this specific issue. I think that they lay it out very well. I think they're telling us which cases they relied upon in making the argument. I think that they're properly telling the court, listen, the law that goes into effect, before the time of sentencing is the one that matters, right? So if there was no law change before sentencing, obviously we would still be using the 2019 one, but the law changed before he was sentenced and we used the proper version. And I think that's a worthy argument. And I really, 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 really agree with them. But let's go ahead and carry on. Ramos v. Louisiana does not require a unanimous jury recommendation of death. Appellant next argues that the Sixth and Eighth Amendments to the United States Constitution require a unanimous determination to sentence to death a convicted party. He erroneously relies on Ramos v. Louisiana for the premise and urges this court to reconsider its holding in State v. Poole. But Ramos only considers the need for jury unanimity under the Sixth Amendment in reaching a conviction, and it does not even address the Eighth Amendment. Florida's death penalty scheme avoids arbitrary or capricious sentencing. Appellant claims that this court's elimination of proportionality review in Lawrence v. State, when combined with the elimination of the requirement for a unanimous death recommendation and an expansion over time of the number and scope of aggravators, does not provide the heightened reliability demanded by the Eighth Amendment in the determination whether the death penalty is appropriate in a particular case. This, appellant argues, has resulted in Florida's capital sentencing scheme failing to genuinely narrow the class of defendants who are eligible for the death penalty, violating the Eighth Amendment of the United States Constitution and the principles set forth in Furman v. Georgia. Appellant failed to preserve this issue for appeal. Appellant fails to cite where in the record he preserved this claim by objection, exception, or motion below. His failure to cite the location in the record where he preserved this argument would generally result in a waiver of the argument for failure to properly brief it. But the court has held that even when the party fails to preserve its objection, an appellate court will still conduct appellate review of an unpreserved claim, provided the party can demonstrate fundamental error. There is no fundamental error because the claim is meritless. In capital cases, a fundamental error in sentencing is one that is so significant that the sentence of death could not have been obtained without the assistance of the alleged error. Any contention that this claim demonstrates fundamental error contradicts the court's precedents on this issue. The court has addressed the claim numerous times in previous appeals and found it meritless, including as recently as May 2025 in Wilson, when the court stated, "As Wilson acknowledges, this court has repeatedly rejected the argument that Florida's death penalty scheme fails to sufficiently narrow the class of murderers eligible for death penalty and thus violates the Eighth Amendment." Appellant argues that under Florida's capital sentencing statute, as interpreted by this court, there is virtually no narrowing of death eligibility before the conclusion of a capital trial, as aggravating circumstances do not need to be alleged in an indictment. However, this argument ignores the explanation provided by the court in Profit about its opinion in Furman. In Profit, the Supreme Court focused on its concern in Furman about unguided sentencing determinations. That is, how the narrowing occurs, not when it begins. The court held Florida's death penalty scheme was constitutional because it satisfied Furman's requirements that the sentencing authority's discretion is guided and channeled by requiring examination of specific factors that argue in favor of or against imposition of the death penalty, thus eliminating total arbitrariness and capriciousness in its imposition. In addition, as the Supreme Court noted in Profit, that after a defendant is convicted, there is an informed, focused, guided, and objective inquiry into the question whether he should be sentenced to death. If a death sentence is imposed, the sentencing authority articulates in writing the statutory reasons that led to its decision. Those reasons and the evidence supporting them are conscientiously reviewed by a court, which, because of its statewide jurisdiction, can assure consistency, fairness, and rationality in the even-handed operation of the state law. Appellant's argument also ignores the critical role of judges in Florida's capital sentencing scheme. Many jurisdictions, in the wake of Furman v. Georgia, wanted judges with their greater experience in criminal matters to be the sentencer in capital cases in a belief that a judge's involvement increased both reliability, accuracy, and uniformity. Florida was among these states, adopting judicial involvement in capital sentencing to decrease arbitrariness in capital sentencing. Florida's death penalty statute provides for significant judicial involvement in capital sentencing instead of relying only on the jury. The current Florida death penalty statute may only require 8 juries to recommend a death sentence, but the law also requires that the trial judge independently agree with the jury's recommendation of death for a death sentence to be imposed. Okay, you guys, let me just go ahead and stop right here and explain this to you. So, I know we talked about another Florida case that did not implicate the death penalty or the death sentence at all. Or I say cases because so many people were involved. And those are the cases of the Adelsons, if you guys will remember. In this specific case, so in Wade Wilson's case, I watched the sentencing for it prior to making this video, and I did see exactly what the prosecution is arguing. So, yes, the jury recommended that he be sentenced to death. But after the recommendation was made, the judge went through the rationale, read his rationale, and then agreed with the jury's recommendation and so sentenced Wade to death. After both phases, so i.e., the jury deciding death was appropriate and the judge deciding death was appropriate, was when Wade was sentenced to death. And I think the prosecution makes a valid point. He doesn't address that here. He's just like, it was left up to a jury and the jury should be unanimous. But what about the fact that the judge agreed with the jury's decision? Appellant cannot demonstrate that the heinous, atrocious, or cruel hack, aggravator, or its corresponding jury instruction is unconstitutional, either on its face or as applied to him. In this claim, appellant argues that the hack aggravator is unconstitutional both on its face and as it's applied to him. His entire argument consists of quoting verbatim the first 6 paragraphs of his 7-paragraph motion filed in the trial court, and which argued that statute 921.1416H and its accompanying jury instruction are unconstitutionally vague and overbroad, are not capable of constitutionally narrowing instruction, and can only be applied in an arbitrary and inconsistent manner. The motion concludes that the vague statutory language of the aggravating factor and the corresponding jury instruction allows imposition of the death penalty for improper and unconstitutional reasons such as race, gender, ethnicity, religion, and social status. Appellant, however, waived this argument by failing to properly brief this claim. But even if he had not waived it, the claim would fail because he has failed to demonstrate that the hack aggravator and jury instruction are unconstitutional, either on their face or as applied to the appellant. Okay, I'm going to stop right here and just explain that a little bit more. I don't remember if I said it. I've been recording a lot lately, you guys, so I don't remember if I said it in my last video. But basically, I know in one of the videos where I talked about something, I told you guys that I really don't like it when people whine. And when you're making a record or an appeal to the court or an argument to the court, just whining and being like, woe is me, woe is my client, isn't really effective. So I think that's what the prosecution is catching on to here. Basically, what they're saying is, yeah, he's saying that it's not constitutional, but did he explain it? Right? Basically, that's what they're saying here. I think it's interesting. I really like this prosecutor's writing style. And no, if you guys have been watching me relatively recently and you haven't been here for a long time, let me just say this. I'm not always pro-prosecution. There's many times where I look at defense cases or defense briefs or whatever, and I'm like, oh, they did a phenomenal job. I just think this is one where, in my opinion, I'm tilting more towards the prosecution's argument because they make better sense to me. But let's go ahead and carry on. Appellant cannot demonstrate that the cold, calculated, and premeditated aggravator or its corresponding jury instruction is unconstitutional either on its face or as applied to him. I'm going to stop right here just because that argument is duplicative of the last argument that we just discussed. The only difference is that it's talking about a different aggravator. So we're not going to read it. We're just going to assume the same argument is made. Yes, he complained about it, but did he explain how it was unconstitutional as it relates to him? Okay, now let's go ahead and conclude this brief. Conclusion. Wherefore, the state respectfully requests that this court affirm the judgment and the sentence in this case. Okay, so you guys, I really enjoyed the writing in this brief. You can imagine reading briefs all day after day after day after day after day. It becomes monotonous and kind of tiring. I really enjoyed the tone that the writer on the prosecution side had in this brief, and I also enjoy the arguments that were made. Okay, it's my understanding that Wade, via his attorneys, replied to this response from the prosecution, and we're going to get into that. But again, you'll have to wait until the next video. Before I let you go, you should know that I love you. I love you and I love talking to all of you. I really enjoy when you guys ask me questions. I really see all the comments that you guys write, even the negative ones. I see everything you say. I really enjoy talking to you guys. I like when you tell me what you like about the videos, and I like even when you offer constructive criticism or even disagreement, right? What I'm not going to stand for, and I'm not sure if I've ever said this to you guys, and at this point I'm kind of just rambling, but you know how everyone is like, or not everyone, you know how Michelle Obama is like, when they go low, we must go high. I'm not Michelle Obama. Okay, I'm not Michelle Obama. I'm not that type of lawyer. If you go low, I'm gonna scrub the ground. we gonna hit the floor. I'm not doing that. So come at me with respect and I will respect you in kind. But if you're rude to me, we'll see what type of mood I'm in when I respond to you, if I respond to you at all. But all this to say, please comment. You guys are like, why would I comment now? Anyways, please comment. Please comment on this video if you liked it. Let me know what you liked about it. Please like, please subscribe. If this is my first video that you're ever watching, hello and welcome, but please subscribe, okay? Keep up with me. Keep up with everything I'm talking about. I drop videos, I would say, with somewhat frequent regularity. At this point, I'm doing 1 to 2 times a week. I'm not going to make that promise to you guys forever, but at this point, I'm doing 1 to 2 times a week. So if you like it, you might as well tap in with me. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.